You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Welcome. Good to see you.
Good day.
Bill, we haven't talked about the Madoff Ponzi scheme lately, but you have come to us with a story that has you all kinds of worked up. What's going on?
New York Attorney General Schneiderman and the Madoff trustee both have sued a chap named Ezra Merkin. Mr. Merkin ran several feeder funds for Madoff. In other words, they collected money from their investors and then sent it into Madoff. The Attorney General claims that Mr. Merkin collected hundreds of millions of dollars of fees throughout his career as a Madoff feeder fund. Next, we go on to lawsuits. The AG sues Mr. Merkin, and for that matter, so does the Madoff trustee.
And there's nothing too unusual about any of this. I mean, this is kind of routine.
What one would expect. The AG makes a settlement with Mr. Merkin for the cool figure of $410 million. Already, that is, okay. Nothing interesting there. Next, however, it starts to get interesting because District Judge Jed Rakoff, who is hearing part of the Madoff affairs when they go to district court, is allowing the settlement agreement with Mr. Merkin to be sealed. In other words, completely secret. Now then, it starts to come out in some snippets of court papers that Mr. Merkin is receiving some portion of the $410 million. In other words, if you want to put it in more pejorative terms, that a Madoff henchman is going to receive the benefits of some of the money that was stolen from Madoff.
Well, that's
customers.
unusual.
So in other words, we've got two parts here that don't really suit some people terribly well. Number one, this settlement agreement is sealed, not public, when there is at least the possibility that some portion of this settlement money is going to go to the chap himself who assisted Madoff in taking this money away from innocent investors.
Why should the money go back to?
Well, that's what I'm not clear
Merkin
about and won't be at all clear about until and unless this settlement agreement is disclosed publicly. Now, the Madoff trustee has alleged that Mr. Merkin knew all along that this was a Ponzi scheme or a fraud. Now, we have to be clear. I don't know whether that is true or not. Mr. Merkin could have been as clean as the driven snow. It is surprising me here that Judge Rakoff, who is one of the finest district judges we have, has so far allowed this settlement agreement to remain a big secret, especially when it's now coming out with little snippets publicly that Mr. Merkin is going to be the beneficiary of some undefined portion of this settlement. Lee, this is a matter, really anything having to do with Madoff, and especially a $400 million settlement, is a matter of great public interest. And it is atypical for federal courts to allow papers such as these to be sealed and the matters to be basically all concealed from the public.
So what's next?
There will be a hearing on the 12th of March in Judge Rakoff's court, and I suspect and hope it will come out there. So maybe, Lee, about 2 weeks from now, we'll have a further report on what was going on.
All right, let's talk about ResCap. ResCap, of course, is the mortgage servicing subsidiary of Ally Financial, which, of course, was bailed out by the federal government back during the crisis. ResCap filed bankruptcy in May with a $750 million settlement with its parent Ally that was supposed to allow the case to end quickly and painlessly. That, needless to say, has not happened. Now it appears the case is going back to square one, in a sense. Why is this happening?
Well, I think actually, oddly enough, it's a good thing. Some creditors did not like this settlement in the first place because they thought for Ally to bail itself out for $750 million was a bargain by magnitudes. Well, it has now transpired after pressure from the creditors committee that ResCap has backed off from the settlement. In other words, they are formally terminating the settlement with the parent Ally. Next, ResCap has agreed that the creditors committee for ResCap can sue the parent Ally. This, I think, all things considered, is a good development because come sometime in April, the examiner is going to issue a report about this proposed settlement and a lot of other things. You know, the way things are in bankruptcy, Lee, until you can really bring pressure to bear, nothing but nothing happens. So now that maybe the creditors committee will be free to sue and there will be an examiner's report, we maybe actually will have a conclusion to this case before I go on Social Security, which, by the way, is not terribly long from now.
And also, interesting item, Bloomberg News is in the news itself, and if we're talking about on this program, I have to say I'm a little bit concerned here. Does this mean Mike Bloomberg is approaching the bankruptcy precipice? I hope not.
No, not hardly. What happened was this. There is a case called PT Berlian. It is an Indonesian tanker shipping line that, for reasons I don't need to explain, ends up in bankruptcy court in New York.
Right. Shipping has just been flying on its back for a long time, as long as we've been doing what we're doing.
The worst industry you could think of to be in these days. The company is also in bankruptcy in Indonesia. The Indonesian courts allows all of the papers in the bankruptcy to be sealed. So the PT Berlian people came to New York and said the same thing to Chief Judge Stuart Bernstein and said, we want to file everything under seal. Well, as you can imagine, Bloomberg News didn't like that one little bit. Mm-hmm. And God bless the folks here, they filed papers opposing the sealing, and Judge Bernstein came down very strongly on the side of the media and said that indeed everything is going to have to come out, and it is very likely that he will not allow anything to be sealed. Mm-hmm. I certainly hope that Judge Rakoff does the same thing at that March 12 hearing we talked about a minute ago.
Yeah, we're hearing more and more about parties in bankruptcy litigation trying to get the proceedings sealed. Why is it increasing? It feels like we're talking about this a lot.
You are right. I see it all the time. And the fact of the matter is, judges don't, as they should, make independent judgments about whether sealing is proper. In district courts, for example, just an agreement between the parties don't get you sealing. You have got to show the judge some compelling reason why somebody is going to be severely prejudiced, not embarrassed, but severely prejudiced if papers become public.
And finally, we have several important circuit court cases this week. What did you find that was unexpected?
Well, the first one, Fifth Circuit, in a case called Camp Bowie. The Fifth Circuit ruled that artificial impairment is no reason for refusing to confirm a cramdown plan. Now, if you know what artificial impairment is, I don't need to explain it. If you don't know what artificial impairment is, then you don't need to know what it is in any event.
Ignorance is bliss in this circumstance.
Let's leave it this way. There is a split of circuits. The Fifth Circuit and the Ninth Circuit now agree that artificial impairment is perfectly okay. The Eighth Circuit is on the other side saying you can't do it. The other decisions we have are both from the Second Circuit and, by the way, both in the Madoff case. Both of them very short opinions. In the first one to come down, the Circuit Court held in an unsigned opinion that individual Madoff creditors cannot sue people like Madoff family members. Those claims belong only to the Madoff trustee. The second case was a signed opinion, only slightly longer, in which they said that investors in feeder funds do not have direct claims against Madoff. They only have claims against their feeder funds. This was a very important decision. And it was also important in both cases because they were so short. In other words, the Circuit Court had no problem with the trustee's position, thought the trustee was absolutely clearly correct. Now, the really big show in the Second Circuit for Madoff is going to happen, I'd say, maybe 3-4 months from now. That's when the Circuit Court is going to hear argument in a case that will tell us whether or not the Madoff trustee can sue going back 6 years, because at present, District Judge Rakoff is only allowing suits going back 2 years. So, if the Madoff trustee pulls this iron out of the fire and can sue going back 6 years, it means the customers, I think, are probably going to get a full recovery without a whole lot of trouble. But that's yet to be seen. But that is the really big Second Circuit issue yet to be argued.
All right, lots going on. Bill, thanks for stopping by. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go read Bill's column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching, and see you next week.